law schools across the country. I give lots of topics, some of them on free speech, some of them on federalism, some of them the separation of powers. Oh, my blog's down. Did that just happen? Oh, it might be DOS'd. Okay. All right, well, YouTube's still up. Anyway, so I often give speeches at various law schools. I've never really had any incidents there. But about 2 weeks ago, I spoke at CUNY Law School. CUNY is a law school in New York City. I'll play it. What the hell? And my topic was actually free speech on campus. That was the topic. Yeah, irony, right? You guys think this is funny. So the topic was free speech on campus, and usually the way it works is you find a professor on campus who's willing to comment or engage, and they couldn't find anyone, which was my first sign something was up. The second sign was a couple of days beforehand. One of the students emailed me and says that a protest is being organized. Like, what do you mean a protest? Well, they're going to protest you because they think free speech is a shield for protecting white supremacy. So I show up at the building the day of the event. I show up. I'm there. And the security guy comes in and says, what's your exit strategy? I'm like, what? He said, how are you exiting the building? I'm like, at the front door. I don't know. He said, well, we may have to remove you from the room. I'm like, wait, what? I said, I'm taking an Uber. He's like, okay, Uber is good, not the subway. And then I'm like, what's going on? And apparently there were dozens of people massing in the hallway outside the law school, right where I was about to speak. And I was like, what do you mean they're massing? And they were there. They actually had arts and crafts. They were making protest signs, had markers and poster board and everything else. And then the security guy said, I'm going to escort you into the building. What do you mean you're going to escort me into the building? He's like, I'm going to escort you into the building. I'm like, okay. I wasn't planning it, but you asked, so I'll play the video. There's some very bad language in here, but not for me. Well, actually, some of it's for me also.
How you doing, guys?
And there was no one in the room. Behind them, it was just one of them.
I'm sorry. I don't know. I'm not sure what would actually work here.
I had several cameras rolling. I had a sense this might be like
So we're going to ask you please to stay to the side or in the back.
this is the guy who's the president of the local Federalist chapter who hosted me.
Pursuant to.
So I can go get Steve Katz or a
You don't have to go that far.
So, is this? I mean, if it is, it's fine. Is this acceptable under rules?
But also, they have like 5 people, so if you don't want to give him an audience, so he doesn't write about our blog tomorrow. So I'd rather not give him content for even a few minutes. So it's just giving you that choice. Some of us are just going to be outside.
Film back. I didn't know that.
You alright?
We're all walking up. And that's after changing the
Just let me know when you're ready. Okay?
I'm
Let me know when you're ready. Whatever you want, yeah.
And all 7 of you guys showed up. Had to be the
I
white
don't understand how Julie allows this. I just don't get it. I don't understand.
There are students that are directly affected by
It's really a lot of views. Legal objectivity is a myth.
You still have an opportunity to leave.
Yeah, this one also not right. So thank you guys for coming. I'm here to introduce Professor Josh Blackman from the South Texas College of Law. He's here today to discuss the topic of freedom of speech within the context of university.
I don't understand.
Professor Blackman has written numerous articles on numerous constitutional topics, and he's given this speech many times before. Thank you. And so, Professor Blackman, everyone.
He's filming us, so everyone
Well, thank you very much to CUNY for having me.
White men and those who support white supremacy.
I'm not white. I'm not white.
Then why send those who support white supremacy?
Excuse me, I think it was already explained to you that you're not supposed to interrupt the speaker once he starts.
Alright, listen. Everybody stop. Let me tell you something. The university rules are people get to speak. You may protest. You may protest, but you may not keep anyone from speaking. If you do, I have other things to do. I will be back. Or you can resolve this yourself. Or you can have me resolve it.
Why are you bringing racism to your school? Can you answer that?
Why haven't you provided support for students who are affected by hate speech?
You here.
You're not children, you can't talk to us about that.
Please don't take the bait. Don't take the bait.
She is threatening you guys. It's ultimately her choice whether she wants to do something. It's not our choice.
It's totally within her discretion. She is literally making that choice, not us.
So, for those of you who are actually here to hear me speak, I'll try. When I came today, there was a sign or panorama that says oppressors not welcome. And it says at the bottom, we reject the idea that his views, my views, merit space on this campus, and reject the myth of legal objectivity. Josh Blackman is not welcome at CUNY Law. Congratulations, you made me feel not welcome, but I'm still going to say what I'd like to say. Thank you, I tried. So, I actually want to start by using the one legal argument you actually made. You said the violence exists in the law, and it's a myth that law is inherently neutral. Okay? And you said there's a myth of legal objectivity. So let me talk about legal objectivity for a few minutes, right? Someone did some excellent opposition research. Whoever did this, I actually applaud you. You found about 7 or 8 bullets on various videos I've given over the years. But I want to make a few points. For example, you wrote that I supported the President's decision to rescind DACA. Now let me tell you something. I actually support the DREAM Act. This might surprise you. I actually think the DREAM Act is a good piece of legislation. And we're a member... Oh, let me speak, please. And we're a member of Congress. I would vote for the DREAM Act. My position is that the policy itself was not consistent with the rule of law, which teaches a lesson, right? The lesson is this. You can support something as a matter of policy, but then find that the law doesn't permit it. And then the answer is to change the law.
Fuck the law.
Why don't you support people? Why don't you support
Fuck
people?
the law, right? That's a very good thing. You are in law school, right? And it's a bizarre thing to say fuck the law when you're in law school.
Welcome to CUNY. You chose CUNY, didn't you? Since you knew what would happen if you came here.
Well, if you let me speak, let me speak. So fuck the law, right? That's a good mantra, fuck the law.
How many of them?
You do. And I'm actually very impressed. Let me say this. I'm actually impressed that there's so many chose to come out here and exercise your constitutional rights. You want to exercise your rights,
We're just
I'll
not
do the same.
law because they are not acting right.
And I'm here the same. So I'm going to express my views. So let me go down this list you have. You have this little checklist, right? I think DACA. You want to go? Please leave, by all means. I think DACA is a good policy.
I think you're tired.
No, I'm feeling pretty good.
You're lying. I think you're white supremacy.
Okay.
Fuck.
Oh, that.
This is really about CUNY law and how you let this happen. And shame on all of you for being here. How could you let that happen?
I don't support this plan.
Then why are you here? Why are you here? Shame on this school.
I don't care.
Howard.
I want to ask them a really hard question, which we should all try to ask them very hard questions. Like the notion of legal objectivity.
Yeah, let's talk about that.
But it's now underlined by the fact that the Constitution was founded under white supremacy.
Yeah.
So the whole notion of neutrality is a false notion because it's a false notion.
Let him talk. Let him talk. Let him talk. Let him talk, please.
And I think that's a truism. So I think the idea of legal objectivity, ideally, that's what we strive for in the law.
It gets quiet after this. I then go on to have a dialogue with the 5 students who are actually in the room for like another, hour and 10 minutes. We were talking at some length. There's a lot of things I can say about this. Let me put this into context. One thing you probably don't appreciate about South Texas is it's a pretty welcoming place. And I mean that in many senses of the words. I've never once had anything at the school where someone said, you can't say that, you can't say this. No one's ever shouted me down. I've never been protested here. But that's somewhat unique. The students here had about 4 or 5 days notice I was coming, and they decided to organize a massive protest. Now, what did I do to warrant this? Nothing really. I didn't say anything to them. I didn't do anything to them. But they had this assumption that I was here to spread white supremacy, genocide, fascism, whatever you want. Use whatever adjective you want. And they protest me. Now, let's be clear. I haven't taught you the First Amendment yet, but this is a state institution. It's a city college. They have the right to protest. And had they just been in the hallway protesting, I would have been fine by it. Makes for good footage, right? Had they just stood in the back of the room with their signs up, I actually wouldn't have cared. They only crossed the line when they started heckling me and interrupting me and shouting me down and preventing me from speaking. And it's a very hard thing. You probably see these videos on YouTube of people get shouted down. What do? Right? Do you yell at them? Do you bait them? Or do you engage them? And I chose the latter approach. I tried asking them questions. And the second I started asking them questions, they started leaving. Right? They couldn't handle an actual engaged debate. You saw this, right? Oh, I don't want to hear this. They don't want to hear it. Their minds are closed. And it's a damn shame. A damn shame. They're in law school. They're the same as you, right? Same age, same, studies, or taking the same class as you are. Yet you can sit here and laugh your butts off at this, and they were genuinely offended. After this, I think they ran to the dean's office and complained to the dean that they let me on campus, that they even let me in the building. This is a very sad trend. This is my first time being protested. I'm sure it will happen again. You wonder what I'm doing. I'm not with you. This is where I am fighting the fight. But, I feel blessed. I'm at South Texas. That kind of school probably never hire me for good reason because they wouldn't want someone like me on campus. But I'm happy here. You guys are well-behaved. You always respect each other's views. You can have a civil discourse. My guests were here last week said, oh, my God, you had a class on abortion. No one was yelling at each other. That's actually a remarkable feat. You may not think we had an entire class on Roe v. Wade, and no one got to yell at each other. That doesn't happen at other schools. It doesn't. I can tell you that. This is what happens if you say anything outside the mainstream, whatever the party line there is. I mean, at CUNY, if you're to the right of Bernie Sanders, you're a fascist. I mean, that's basically what things are like there. But I'm not joking, right? Anyway, I have stuff I actually want to cover. I didn't plan on doing this today, but someone asked, so I did. I hope I'm doing it again properly. I was just going to watch the video. Any questions about this? I'd be happy to address it. Yes, sir.
Wow. I mean, obviously, you're going to keep doing what you do, but in any way, how do you take it a little bit personally, or would you modify anything you do in the future?
No. No, and a couple of you noticed I was actually granted tenure 24 hours for this protest. The timing. Oh, thank you. I mean, I don't make a big deal about it. It's a contractual matter. It's not a big deal. But the important reason why academic tenure exists is so schools can't fire you for this sort of stuff, right? What tenure means is it's a for-cause removal standard, like in Morrison vs. Olson, to use an example, right? You have to have malfeasance, something bad. You can't just fire someone for engaging in protected speech. So the short answer is no, I'm not going to shut up. I mean, look, I showed this speech to my dad, and my dad's like, "You can't do this. If they're protesting, you stay behind. They're going to hurt you." They weren't going to hurt me. They weren't going to lay a finger on me. This one guy tried blocking me. He didn't actually mean it. He put his backpack in the door or whatever, right? He didn't mean it. He didn't actually mean it. But the point is, if you back down from people who want to stop you from speaking, they prevail. And I was going to walk into that room. I was going to hear them out. I was going to ask them questions. It's easy for me to play a 9-minute video now. I don't know what's going to happen. They could have been there for an entire hour, right? They actually run out of steam very quickly. They actually can't maintain it. We deliberately started the event 20 minutes late so they would get their steam out, and they still made it like only 8 minutes. Yeah, Gabe.
So I just want to confirm. What was it that they were protesting? They were a KKK and what else?
So I mean, look at the signs. I mean, in the hallways that they said that I'm a white supremacist and I'm a white nationalist and homophobic, transphobic. The entire. Yeah, I mean, white supremacy. This is my favorite sign, though. I'd say by a long shot. Your legal analysis is lazy and wrong. I'll actually give her. I'll give her half of that sign. I won't tell you which half, but at least half of that sign is correct. I'll tell you which half though. But yeah, Gabe, I don't know. I think the mere fact that the school is not used to having any person right of center speaking, and that I'm affiliated with the Federal Society, which is a conservative group, they assume that I have to be like Milo Yiannopoulos, something like that. They just assumed without anything else. Yeah.
I was just gonna ask, one of the signs that the Federal Society promotes white supremacy, white. I didn't understand where does that come from?
I don't know. I think it's a presumption that anything that's even remotely associated with conservatism is no different than the Klan. It's a reach. I mean, a couple weeks ago, the Federal Society gave me an award for teaching, and Justice Thomas was the keynote speaker at that event, and he discussed my award and stuff. It's whatever. I don't know. Anyone else want to say something? No, I'm not. No. I don't need applause. You need to think about your colleagues at other law schools and recognize this when it goes on. Yeah, Kenny.
Where did they get the no charges stuff? Did you say that's unconstitutional?
Yeah. Yeah, I have. Yeah, my position on DACA is that I think it's unconstitutional policy, one I like. And I was trying to engage them on that. You can actually think a policy is good, but think it's not justified by the law. Yeah. Yeah.
So this was your first time experiencing something like this. I want to know how you felt. I know you said you felt unwelcome, but with them calling you white supremacist.
It was weird, right? I mean, I'm the grandson of a Holocaust survivor, right? It's a bizarre thing to be called a white supremacist and a fascist. It's very strange, and their facts were wrong. I think people would agree with that, but it was very bizarre. In the moment, I wasn't really thinking about it, if that makes any sense. I didn't have a blueprint of how to react to this. I was more or less going with the moment. In hindsight, though, I don't feel bad for myself. I feel bad for these students. I really do. I mean, I got over it. I went home. I was with my family. It was fine. But I feel bad for these students if this is their conception. If they view anyone who doesn't toe their party line, someone who has to be shut out of campus, I feel bad for them. And I mean that sincerely. I wish there was more of a presence on their campus. Professors could talk to them, explain that maybe it's not the right idea. But it was, I don't know. It's a hard question, and I still don't know exactly how I feel. But at the moment, I wasn't thinking through. I was ad-libbing, if you will. Thank you. Yeah.
It seems to be kind of widespread across the nation now.
you think, like, I want to know where do you think they get this foundation from? Because it seems like they just kind of go with the flow.
I don't know.
Or do you think they want to maybe be the next school that's featured protesting somebody?
You know, the weirdest thing about this, and this is one of the weirdest thing about it. There was one student, the girl standing right next to me. She said, "You knew this would happen if you came here," and like, it didn't occur to me at the time. I mean, to Malias' question, I wasn't really listening to what they were saying. I was really in a weird place. But I went back and watched. Like, wait a minute, they thought I was baiting them, right? Yeah. I knew about an hour in advance this would happen. Yeah. I knew that people were going to be protesting, but I didn't know about an hour in advance they'd be demonstrating like this. Maybe 30 minutes. It was pretty quick in advance. I would always record my events, but I had my camera and I was walking in the hallway. But to your question, yeah, I don't know. This sentiment that they have, there's definitely a lot of anger, and I get that they're angry. The target of their anger, though, and the way they express it, though, is where I object. They have the right to protest. I don't have any objection with the hallway demonstration. That was fine. It was the shouting down. That's the only place where I ran off.
I was just going to say that thank you for allowing us to take this 5 times to do this, because truly, as we were laughing at them, I was thinking about the bubble we live in. We live in Houston, Texas, they're in New York. And to know that we would never receive it that way, maybe because we've been around you, we know some of the things that you've done, we've watched some of your CNN, some of your various points that you give. And I think for me, it really made me sit back and think about what you just asked. And I think it's just another symptom of what's going on just across the board in our country, the divisiveness. Because when people say Federalist, they automatically, everyone's conservative, the same type of thing. But if you go deeper and you learn and you talk and you have an understanding, then you understand it's not just about that, and that's not even the issue. And I think the sooner we can have freedom of speech and be able to even have a dialogue, constructive dialogue with each other, we can come closer to solutions for the problems in our country. This is just a small tidbit of what's really happening in our government.
Thanks, Yvonne. I appreciate that. Yeah, I'm trying not to draw any big pictures because it's very difficult. I tried doing a count. It's actually really hard to count. Maybe 40 or 50 people in the hallway. There were a lot of people in the hallway, only 5 people in the actual room. But they were really motivated. Something was really bothering them. And that they took the time of their day to do this meant something was really bothering them. And I get that. I recognize that. Yeah.
So 2 questions. First, do you feel or do you think you were like set up?
Set up?
Yeah.
Yeah. Yeah, I think probably. Yeah.
The second one was, these guys are law students, so they're supposed to be one of the most, like kind of lighted above the average, whatever citizen. These guys are future district judges, justices. Do you think this is, I don't know, like worrying?
Yeah. So Carlos makes a good question, right? And I make this point a lot. Today's law students are tomorrow's lawyers, are the next day's judges, right? And if there's ever a free speech case that comes from these people holding their signs, I'm not confident that it comes out the same way it would have come out with someone else on the bench. And one of the things I do in my side business, I do a lot of lecturing to high school students, talk to high school kids, and often, I'll show them this video for sure now, but I often tell high school students that when you're in a college campus in a couple of years, you need to recognize the risk that's posed by removing platforms from speakers. If you don't want to hear someone speak, don't go. Right? Ignore them. Protest outside. Fine. I have no objection whatsoever to protesting outside. It makes no difference, man. If they were just in the hallway shouting, whatever. But it's the idea that you can't even speak. Right? Chase?
Well, so you talked about how that was, since they were a public institution, they had that right to do that. I know the University of Denver, I have a friend on there, they also are protesting a federal speaker that's coming. Since that's a private university,
Different rules.
Different rules.
So South Texas is a private college, right? You all knew this is where your tuition's a little bit higher than it should be, perhaps. We actually keep your tuition low, but it's not a in-state tuition discount. Private colleges are not bound by the First Amendment. We know that. But there's a tradition of what's called academic freedom freedom of expression on campus. It's not governed by the Constitution, but it's governed by norms on campus. If a private school wanted to disinvite me, they would be within their rights to do that. I think that's troubling, but they were within their rights. Had CUNY disinvited me, that give rise to legal action because it's basically viewpoint discrimination. Clinton and David.
I was going to ask you, are you going to prepare like a response for the students at CUNY?
I'm not planning on it. No response. I mean, what should I respond? I mean,
just because I feel like you really didn't get to say what you were trying to.
Look, if they wanted to watch me, I was there for another hour talking. They could have sat in the back of the room. They could have asked a question. They left, and they weren't interested in hearing what I had to say. And that's actually what kills me the most. That's actually what bothers me the most. I actually wanted to engage them. I planned to be asking them questions, and they didn't want to do that, right? I didn't yell at them. I didn't call them names. I didn't try and shout them down. I wanted to engage them. They weren't interested. No, they're on their own. I'm not their teacher. Right? I'm not the professor. If they're that close-minded, I'm not gonna waste my time on them.
I reviewed a lot of their signs you posted, and then I've also reviewed the Federalist Society website. I think, did you feel that they were upset with you, or they were upset with the Federalist Society?
I was a spokesperson, I suppose. Yeah, I think, again, I don't think they were mad at me, Josh Blackman. I think they were mad at some bigger issue, and I was merely the spokesperson who was there. And I was a representative that they want to target their focus on. I don't think this was about me. Maybe it was. I don't know.
Yeah, it didn't appear from their signs. It looks like they're upset for the Federalist Society, and I understand. If you look at there's some reason I can see where they come from, based on what's on the Federalist Society. I think they misunderstand. I wish they would have paid attention to what you had to say, because they frequently last question number 2 leads to what they're saying. But if they would have listened to you, they probably would have understood that that's not what it's about.
My legal analysis is lazy at times. I will give them that. Yeah, Abdul.
I mean, you shouldn't take it personal at all. I don't think it's about you or the Federalist Society. It just happens to be at this time in history, or this time in, during this time of the year and so on. The docket seems to be one of the things they brought up, even in the posters. So it's a pressure point. It's something that they're obviously very emotional about. There are people that know, or at least believe, that at any moment them or their family members could be reported. Yeah. So they're not going to act logically. It's very emotional thing.
Yeah, I've given debates on DACA before and DAPA before. I've given debates on the travel ban before, and this is something that affects people. I did one event at the University of Michigan Law School, and a professor there, I was debating on the travel ban. He was a Ginsburg clerk, smart guy. He said that I enable evil. Whoa. I enable evil. He compared me to the lawyers defending FDR on Korematsu. So, I'm used to this sort of barb from other people. I'm not fazed by it. I think it's a terrible policy, but it's lawful. Which I always make clear, but I enable evil. Yeah.
You said there's that you want to ask some questions. Is there a particular line of question you want to go along?
Well, what happened was they passed around this pamphlet, which listed a number of grievances against me. Think of Festivus, right? The airing of the grievances. I want to go down them one at a time and talk about them. In fact, the first grievance was about DACA, and that's why I started asking about DACA. There were like 7 or 8 things on that flyer. I was going to go down every one. So let's talk about this. 1, 2, 3, 4, 5. That was my in my 15 seconds of preparation. That was my plan. I didn't actually have a plan. I have a 30-minute set speech I usually give in the topic. I wasn't giving that today. They was not going to let me. So I was going to try and ask questions, but I didn't get to my second question.
Where did you get the handout?
They were passed all over the building. I actually found one in the trash can, which I suppose is fitting. They had me in this holding room beforehand. I was looking at the trash, and I was like, "What is that?" And I said my name. I was like, "Oh, this is me." These little square pamphlets. I actually have the signs. They left the signs in the hallway. I brought them home. I have them at home. I have an entire bag of signs. No, I don't have that sign. That sign's not there. But there was another sign that said, "Go home and blog about this," which I did. So I think I might frame that sign, hang up in my office. I don't know.
Who was the woman who stood up for you?
She worked in the dean's office. I don't even know her name. I didn't know who she was. She came by. Yeah, Abdul.
Can you make sure that sign and put it as part of your blog, like in the top right corner?
Yeah, go home and blog about this. Yeah. All right. Yeah, McKinney.
I just thought it was funny how
they're out here saying like, oh, we don't believe in speech, we don't believe in debate, we don't believe in truth or objectivity. So it's no wonder that you ask them a few questions and they all scatter. It makes perfect sense when you think about it that way.
Look, I mean, so this idea called the heckler's veto, right? So what's a heckler's veto? Right, so imagine someone's giving a speech, right? And the speech is very controversial. And then all the people start rioting and mobbing and say, you know, if we keep speaking, we're going to beat you up. So the cops have a choice. Do you remove the one speaker or do you remove the mob? Sometimes the cops remove the speaker. That's what's known as the heckler's veto. That's what the guy asked my exit strategy, right? How I'm leaving the room. That if it became a violent confrontation, which I didn't think it was even close to that, they would have to remove me from the room. In that case, the hecklers prevail and I get shut up. I don't get to engage in my presentation. So I was not leaving that room. They were going to have to drag me out there. I was ready to make a stand. I mean, you know, martyr, right? Yeah, right. But unless this is my dad. Unless I felt physically threatened, I wasn't leaving that room. I was going to stay there as long as they needed. Or.
So does this incident, will it in any way like alter your approach? And I mean that like in general, like because you post everything on your YouTube and it's more like in your way like also educating others that are not in the classroom. And then you go and speak at different places. Does this incident now alter your mental approach to things?
No, not at all.
You'll just like anticipate that.
I'll be prepared if it happens again. I'll be more prepared for it. I'll have a spiel I can you know, a script I can rely on. But you know, I put my stuff on YouTube because I think knowledge is free and should be shared by the world. I go to law schools and like people say, "Oh my God, thank you, help me pass property." Right? I was at a law school yesterday in Vermont. Okay, that feels good, right? They actually watched my videos, and what they did, the protesters, they actually went through they must have gone through dozens of my videos and pulled out like one sentence quotes out of context to make this opposition research. That was a little pamphlet about it. It was very impressive. I don't know if they had outside help. I have no idea, but they put together a very impressive package. Yeah.
Was that like during an actual class?
No, it was at 5 o'clock in the afternoon. It was an after-school event.
And I didn't see like any like teachers or police or they just let the people just stand outside and do that.
Yeah. No, they're allowed to. There's nothing wrong with staying in the hallway. There's nothing. Again, let me make it very clear. Protesting the hallway is fine, as long as you don't block my entry. Like one guy made a half-assed attempt to block me. It didn't actually work. He was just putting his backpack, just trying to be a jerk. But you know, whatever. That was fine. I got around it. But there's nothing wrong with staying in the hallway. I couldn't care less about that. They can do that. I'm fine with the hallway standing. What else? Yeah, yes, sir. I would go back if they invited me. I would absolutely. I want to engage. In fact, I was thinking about this. I would invite those people who were leading the protest to come sit with me on a panel and talk about it. I would gladly do that. I don't think they would, but I'd gladly do that. Let them ask me questions one-on-one in a discussion, and I'll take whatever questions they have. You can watch. For an hour, I was taking hard questions from the audience for a full hour. These were not friendly questions. They were hostile questions. I took every question. I answered the best I could. I don't mind answering questions. Yeah.
I don't know if this is a fair comparison, but like when I saw the first 10 minutes or so of the video, it seemed pretty similar with some of the pictures you showed us with the high school in Arkansas when they were trying to escort.
Oh boy! Oh no! No! Not even close! Not even close! No! My safety was not at risk. I was never. I was not for a moment in physical harm jeopardy. Not for a minute. I wouldn't make that comparison at all. My physical safety was fine, and that's always important. But I didn't feel threatened for a minute. Those students could have been killed at any moment. So I did not need President to send in federal troops to escort me to ConLaw. I did not need that. Not even close. Okay. My website's ranking DOS at the moment by the students. But we'll see what happens. Someone else have a hand up? Anyone else? If you want to talk about it afterwards in office hours, that's fine. It's a very strange. It's a very. And I didn't mention it. I wanted the video to be out first with a full context, sort of very long post. And you can read the entire post on my blog and just go through it. I tried to be as neutral as I can. I didn't give any commentary. Maybe I'll do that later. But yeah. One plus side. There was one guy holding up a sign saying oppressors are not welcome here. And he actually emailed me afterwards and said, you know what, you're not an oppressor. So, you know, I persuaded one person. Yeah. I unoppressed him. Or I was did I not impress him? Or I don't know. Yeah. It was a little intimidating, but it was more surreal than anything else. And, yeah. Okay. I'm racist. Yeah. They tweeted about it, put on pictures online, social media. Let's see what else.
The school itself?
No, this is a student group. It's not the official. I don't think it is, at least. This is a private account for a student group. I think it's a National Lawyers Guild, which is a lawyers group. Yeah, my free speech. Fuck you, white supremacist. Okay. And this is someone took this picture from behind me. I'm the guy with the bag. They are lined up. I love this. I wish I had this sign. This is something you can say about any of my work. And this guy, he's trying to block the door, but he didn't really mean it.
So this kind of stuff pretty good for your career.
Maybe. I wish it wouldn't. I would rather not have this. And this guy, he actually stayed. This guy asked me questions for an hour and a half. He was asking a lot of good questions. So I took all of his questions. So I respect his opinion. Back to the room. This was a security guy. He was sort of standing in the back, but he didn't really. There was no security threat. There's nothing to do. I think he did a good job as well. Let's see what else. This is my favorite picture of the entire day. It's like, whatever. All right. Maybe one or two more questions. I have actually stuff I need to teach today. Yeah. What? Anyone else? Yvonne, is that your hand up? Yeah. Abso-fucking-lutely. Yes. We haven't done the First Amendment yet. Actually, it's funny. A couple years ago, one of my students brought her 8-year-old daughter to class. They was teaching the First Amendment. I was like, oh god. And I often curse in that class because curse words, swear words, are protected by free speech. Absolutely, right? They're protected. So when they say "fuck the law," that's in their rights. Yeah.
Well, that was the issue in that one case where the guy had that jacket and said "fuck the draft."
Fuck the draft. Exactly. We'll do that case later. Yeah, it's on. I think it's in the syllabus. If not, we'll discuss it. Yeah, Hurrieto.
Any comments on the Union LD Twitter using hashtags like Antifa?
Oh yeah, they were Antifa. I don't know. Whatever. Yeah, Antifa. Right. I don't know, man. They didn't talk to me. They didn't give me a call in advance. Like they didn't coordinate this with me. I sort of just walk in the hallway. I was like, oh, here it is. Yeah, the security guy's like, well, do you want to take the stairs or the elevator? I'm like, which is worse? Like, well, they're both bad because they were actually on both sides of the hallways. Whether they went for the staircase, the elevator, they would confront me. They're organized. I'll give them that. They will really have their act. If they put that much effort into their LSATs, oh, that was mean. Sorry. Okay. Last one. Then move on. I'm sorry. No, I didn't get an apology. Nothing. No apology. I wasn't expecting one, but nothing. I didn't hear a word from them. Anyone else? Okay, let's do some work today. All right, let's transition back to something a little bit less controversial, like abortion. Yeah, we could have done like dormant commerce clause or something boring. Yeah, Clint, last one.
To this, because you usually put that in the class notes, but it's not. You don't have class notes on your blog. These are the class notes, and we don't have a link.
Oh, whatever. They're there. You can read it up here. If I didn't put a link, I apologize. Is it not one there?
Right there,
Yeah, lecture notes are here. I have the link.
Okay, I'm sorry.
Okay, Clint. No worries. It's okay. All right, let's do a question, and this will hopefully an hour into the class transition us into the lecture. So under Roe v. Wade, the state has an interest in protecting fetal life during the second trimester. True or false? True question. me. Okay. Okay, settle down. Yeah, let's move on. Okay, good stuff. All right, so let me stop this here. All right. So, who's next? Lauren, what's your answer here?
I put false.
Okay, why you put false?
In my understanding, the state has an interest in regulating abortion if it has maternal health.
Okay. Okay, what about the third trimester?
The third, they can ban or regulate because it's post-violation.
Very good. Okay, so very good, Lauren. That's correct. So the answer here is false. Let's see. Hopefully most of you got that one right. Yeah. All right, well, a third of you got it wrong. Okay, the answer here is false. So let's review, right? You have the first. You have 3 trimesters. First, second, and third, right? We know that the first trimester, the state really has nothing, right? They can't impose any additional requirements in abortion that doesn't exist for other medical procedures, okay? The state has no interest under Roe in either the mother's health or in fetal life. The second trimester under Roe changes things, right? They can regulate if it's related to maternal health, but not for fetal life, right? So they can pass various laws that might provide informed consent, that might impose a certain standards of care that are higher, but it can't be with the interest of protecting fetal life. And the third trimester is your post-viability, and you can regulate and indeed ban on the basis of fetal life, protection of the life of the fetus. You can prohibit it altogether. Okay. One second. This is the Roe framework, which will be modified in a couple cases we'll cover today. Cameron?
So, do we, because in the Roe v. Wade, it actually says that, like, the 3 bullet points.
Yeah.
Do we imply that point 2 and 3 are for trimesters? So it doesn't specifically say, it talks about viability.
Yeah, and this is a point where Casey tries to clean things up a bit, but it's understood that's a 3 trimester framework. It doesn't exactly say it, but that's what it is. Yeah. So after the 6th month, the state can prohibit it altogether. All right, with me. Okay. So our cases today, which we'll now cover in a fairly abbreviated fashion, concern substantive due process, right? And with substantive due process, whether with Lochner, or with Griswold, or with Roe, or with Casey, or with Bowers, or Holman's Health, the court is attempting to ascertain what liberty interests are protected by the 14th Amendment and what sort of protection should be afforded to those interests. And starting with Griswold and Roe, the court developed a couple different approaches deciding how much scrutiny to afford to various liberty interests. Okay? So we have 2 different approaches, right? We have what's called the fundamental rights doctrine, right? The fundamental rights doctrine. If the court finds that a right is, quote, fundamental, whatever that means, it's given strict scrutiny. And you know that when a right is given strict scrutiny, that means virtually all regulations that are scrutinized by it fall, right? It's very rare that a law will survive strict scrutiny. Okay? It's very rare that a law will survive strict scrutiny. Okay? There's another approach that the court used to recognize liberty interests. And I'll just call it the deeply rooted approach, right? It asks, is this right that you're talking about deeply rooted in our nation's histories and traditions, right? Is this a right that's deeply rooted in our nation's histories and traditions? In other words, is this some sort of novel right that you're just making up? Or is this something that's been around for a long time? Now, there are problems with both And they're both strict scrutiny, by the way, right? They both go to strict scrutiny. But there's a problem with both of these approaches, and it should be very obvious to you. First, what makes a right fundamental? How do you know what fundamental means? There was this test, you might recall, implicit in the doctrine of ordered liberty. I've been teaching this concept now for a number of years. I still don't know what it means, right? It's a lovely phrase. It sounds great, but it doesn't really tell you much. So the court has these very open-ended tests of what's a fundamental right. The second approach, though, is somewhat problematic. If a right is deeply rooted in our nation's history and traditions, then why does the court need to intervene? Right? If this is something that has been protected by the government for many years, why would the court have to intervene? The only reason a case is in court is because the state is not protecting that right, and therefore it necessarily cannot be rooted in history and tradition. Right? If we have a long history of protecting right X, then X is already protected. You don't need a court to reinforce it. So neither of these tests are particularly satisfying to determine what rights are protected. In fact, I don't want you to lose much sleep about how do you know what's a fundamental right, and how do you know whether a right is implicit in the concept of ordered liberty. I don't want you losing any sleep over this because it doesn't really matter, right? The court has not recognized a new fundamental right in about 2 or 3 decades. They just don't. They've abandoned that approach. I still want to teach it to you, but they've abandoned this approach. And in the Obergefell decision, which we'll read in about a week or so, Justice Kennedy more or less got rid of the deeply rooted test. He said, well, of course gay marriage is not deeply rooted. It didn't exist 15 years ago anywhere in the world. That doesn't matter. We'll still protect it. So in the current state of law, 2018, where we are today, and this is something Randy and I disagree on, I don't think either of these tests has much relevance. You'll still learn it, but when you get to Obergefell, when you do the Kennedy opinion, you realize these don't have much weight. Josh, what did you do for the exam? Right? Yeah, I'm with you, man. I'm with you. Try litigating this stuff, right? You think you're worried about an exam? Try litigating a constitutional question when you have no idea what the hell the test is. All right. Damon and then Whit.
I kind of feel these tests are, each one is biased. The fundamental right is biased towards the ones who want to suppress the law and say, okay, what you're banning, trying to ban, is a fundamental right. On the other hand, the deeply rooted are being used for the ones that they want to uphold the right and say, okay, this is to uphold the law, and say, okay, what that this law is banning is deeply rooted, and so it is not. Both of these tests, to my view, are not fair to both ends.
Yeah, I think that's a good approach. Neither of these approaches are particularly fair, and they leave a lot of people very unhappy. Because, let me put it this way: why was Lochner considered so unpopular? Right? Because you had judges making up this right of contract that was getting in the way of the Democratic majority. And you might say, yeah, judges, let the state regulate labor, for example, right? But then, how do you distinguish Lochner from these sorts of tests, right? These things are not written down. They're not here. How do you know that the state shouldn't be able to regulate abortion? Well, you call it fundamental. Says who? How do you know that this right's deeply rooted? If it's deeply rooted, why do we need extrajudicial protection? So the reason why substantive due process is so controversial is because it gives judges a lot of license to roam in the world. And then once you say a right is fundamental, then you can say, Texas can't regulate the width of hallways, for example, in a clinic, right? And we're back to Lochner. Right, we're back to Lochner. Whit?
I was honestly really bothered by the concept of the deeply rooted test because I just didn't see any foundation in any concept of democracy or liberty or however general you want to say that. And Justice White didn't really offer any kind of explanation. And the reason I say that is because, under that rationale, technically slavery would still have, or would have never been overturned, and our country was just kind of...
Wait. Well, how was slavery overturned? Was it a court decision?
No, I know, but if I'm just saying, if the court was to ever have to decide something like that just based off of like prior history, anything bad that had just been going on for a long time would pass that test, just because it's common practice, I guess. Not that they actually did that historically. And so I don't know. I guess where does Justice White and whoever wrote the majority for the Moore case, where do they even found this belief?
Well, so there are two ways you can have change, right? Through the legislative process and through the judicial process, right? The legislative process is always free to change. For example, they ratified the 13th Amendment to eradicate slavery. The second approach is judicial protection. It says even if a right hasn't been protected in the past, if the court finds it to be fundamental, the court will then tell the legislature, no, you can't do that. There are legitimacy problems on both sides, right? So on the one side, if the legislative process doesn't help the so-called discrete and insular minorities, you don't get change. But on the other side, if the court is acting out of its own lane and moving too far, what does that say about democracy? That if the people want to ban X and they can't, right? So there are democracy and legitimacy problems on both sides of this debate. And don't lose sight of that, right? 1 second, we'll come back to you, promise. Scalia, in his dissent in Obergefell, makes a point that says one of the most fundamental freedoms we gain from independence is the freedom to govern ourselves, right? In England, we had the king making the laws, not us. And Scalia writes, when courts do this, it deprives people of the right to govern themselves. So there's always the right of self-governance and also protection of rights that might otherwise be protected. There's no easy answer here, Whit. I'm not trying to sandwich this together, right?
Yeah, for sure. No, just something kind of just clicked to thinking about Damon's comment. Do you think they're applying these tests together as to balance each one out?
Well, let me tell you this way, right? If you're applying this one, the right's going to be recognized. If you're applying this one, the deeply rooted, the right is not going to be recognized. Damon's shaking his head. I think he agrees with me, right? If the court wants to protect the right, they'll go door number one. If they want to go like Bowers, they don't want to protect the right, they'll go this route. And this is why Kennedy has to get out the window in Obergefell. He can't have the deeply rooted test work because you don't get to same-sex marriage that way.
Yeah, but you need both, because isn't the 14th Amendment pretty much all about public interest? You need one that opens the floodgates and one that tries to control.
Oh, what a good way of looking at it. Yeah, one opens the floodgates and one closes it. Good way of looking at it.
The problem I have with the deeply rooted test is it's so subjective. Do you follow the Judeo-Christian path, the pagan path, the Native American path, the French path?
Is the first one any less subjective?
No, it just opens it. The problem that I have with the deeply rooted is it's so subjective.
Ah, so you're okay with one that opens it, but you're less good with one that closes it. So everyone know what a ratchet is, right? Right? I mean, you can only turn it one way, right? Not that kind of ratchet, right? A ratchet, like we do in tools, you can only go one way. So Jonathan raises a point. He's okay with it ratcheting up to protect more liberty, but not right.
No.
Won't go the other way.
You need both.
So when do you go? How do you know which way to go?
How do you know which way?
Yeah.
That's public interest. It's always changing.
How's a judge to know that?
I don't know.
Yeah, Justice Kennedy knows. So Kennedy, I've written about this, likes the open floodgates, not so much with the closing floodgates. Right? So the floodgates are always opening, and they don't close. That's a good way of looking at it. I'll steal that for next semester. Yeah, Sam?
How do you know if the fundamental rights doctrine apply to both enumerated and...
No, good question. If a right is enumerated, it's automatically fundamental, right? If it's in the Bill of Rights, it's protected, except unless the Second Amendment. That doesn't. No, I believe facetiously, but the courts, Justice Breyer makes a big deal about rights being enumerated, but in the Second Amendment he has to read it very skeptically. The Takings Clause also, it's in the Bill of Rights. It protects private property, but the courts basically read out of the Constitution. So this is not even applied consistently, but in theory, enumerated rights are fundamental, in theory at least.
I want to comment on something that Wood said. That he said that we're going to follow tradition and things that have been normally prohibited, like interracial marriage,
Okay.
upheld on this, deeply rooted test. But that's protected by the protection clause. So how do you reconcile between,
Yeah.
that
Well, that's the entire issue, right? If you have a right that's enumerated, you don't have to worry about courts moving out of bounds. But if you're a right that's not enumerated, there is a concern. I think Justice White expresses this. Justice White also dissented in Roe, if you recall, that judges should not be in the business of making this stuff up. Wit, and then we have to move on to the case.
So they're not like applying the fundamental rights doctrine and the deeply rooted test as like a balancing test. It's either one or the other.
The court applies them interchangeably. And I think Jonathan framed it in a very smart way. Like in a case like Bowers, where they're ruling against the right, they're going to apply the deeply rooted test. And in a case where they want to rule in favor of the right, they'll apply the fundamental rights test. You'll see this in a lot of contexts, where there's various tests that the court can use, and depending which test, the outcome is determined. So I think Justice White was very careful, saying, look, we're not going to find a fundamental right here. We're going to say this is not deeply rooted. And that's what White says in the Bowers case. Let's do Bowers. Stephanie? Oh, you're next. Oh, good. Wonderful, wonderful. All right. Thank you so much for getting us back on track, Stephanie. I appreciate it. Remember, it's going to be a rough class today. Okay. We'll finish, I promise. All right. Give me the facts, please, in Bowers.
Sure. So, Hardwick he was charged with violence. There was a drug statute that criminalized sodomy, and he was charged with violating that statute.
Okay. So, Stephanie, is this a criminal prosecution? Is this Bowers? I'm sorry. Is this Hardwick versus the state of Georgia? It's not. Okay. What is this case? No. Well, good. But is this a criminal prosecution? No. What is it? Yes. So just be careful, right? The DA didn't actually prosecute the guy, right? This is an important point. The sodomy statute was on the book. He got arrested apparently for engaging in oral sex with another guy. But the DA is like, I am not bringing this charge. Now, you never think about this, but the decision of a DA to actually bring a charge is very important. Contrast that with Lawrence v. Texas. Harris County DA Chuck Rosenthal, an alum of this law school, decided to prosecute John Lawrence for sodomy. He was pleaded, don't do it. Please don't do it. This is stupid. Let this go. He did it. Had he not done it, we wouldn't have Lawrence. Because the statutes were never enforced. They were on the books, and they had an effect. Don't get me wrong. Having the statute in the books says something to gays and lesbians. It has an effect. But in Bowers, the guy didn't bring the charge. Did not bring the charge. Evan?
What was his injury then? If he can bring the case against the...
It's complicated, but if you have a credible fear of prosecution, you can often bring a civil rights lawsuit. This wasn't dealt with in your excerpt, but it's a in other words, if you think the police might arrest you for doing something, you can get an anticipatory lawsuit. Very complicated, and I don't think this case might even have standing. But he was arrested. He can maybe sue for false arrest. I mean, there are things you can do. He was arrested. It's a lot harder when you haven't even been arrested yet. You say, I might be arrested. That's a lot harder. Yeah.
Didn't you do capable of repetition but evading review? Is that
more what he probably says is, I was arrested once and I might be charged in the future. So it's a similar idea. All right. All right. So Donnie, what did By the way, the actual facts. Let me give you the facts. The Atlanta police. Okay. So how did the cops actually see this? Right. The cops show up at Hardwick's residence. By the way, this is Michael Hardwick, a picture of him. The cops show up at Hardwick's residence, and they want to arrest him for failing to appear in court on charges of public drinking. Right? Come on. Right? They were going to arrest him for basically drinking in public. A roommate let him into the house. By the way, if you have a roommate, never consent to searches. Because if your roommate consents, you consent. Because there's some Fourth Amendment case law on this. As the police search Hardwick's home, they notice the door partly open. Again, when a door is partly open, the police can't open it to rest, but they peered in, right? They peered in. And they found Hardwick and a companion engaging in oral sex. And they were arrested on charges of violating the Georgia sodomy statute. Right? So you ask, how could it ever be that a person using contraception in the bedroom be arrested for using it? This, yeah. Almost exact same thing happened in Lawrence. I'll give you those facts next week. Okay? So, Donnie, what did Justice White rule? What was Justice White's opinion? Yep. Yeah.
Okay. think Justice White ended up saying basically that this only he was saying that the statute was only for homosexuals, and I think the actual statute is just for sodomy periods as opposed to apply to both heterosexuals and homosexuals. But he said in this case that 50 of the states had outlawed it, and it was kind of like the norm, and so they didn't agree with the appeals court that said the district court was wrong, so they ended up reversing it, and it was pretty much saying that the district court had got it right in that sodomy.
Well, are you doing the majority opinion?
You said White, right?
Wasn't White the majority? I think you're giving me the dissent. You give me Blackman?
We do not agree and are persuaded that the sodomy law 25 states should be valid.
Okay, very good. Yeah, okay, that's okay. Good. I thought you were giving me dissent, but you're right. Okay, so Justice White's majority opinion begins with a somewhat odd passage. You might have been struck with. He said, "We're not here judging the wisdom of this law, right? We're not deciding whether it's wise or desirable to punish sodomy." Okay, and he says the states are free to repeal this law, and in fact, state constitutional provisions may provide additional impediments to such a prosecution. But the issue presented here is whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy, and hence invalidate the laws of the many states still make such conduct illegal, and have done so for a very long time. Okay, so let's just focus on how he framed the issue, right? He framed the issue as whether the 14th Amendment confers a fundamental right, that's the phrase, right? A fundamental right upon homosexuals to engage in sodomy. That's defining a right very precisely, right? That's really precise. I think the dissent hits him on this very hard. Shara, what might be a different way that the court could have gone about addressing this exact same issue, rather than saying specifically a fundamental right to engage in homosexual sodomy? What would be a different way the court could have addressed this issue? Think of Griswold, right? Think of Roe. How do they define the right in Roe and Griswold?
It was about privacy.
Privacy. Everyone heard what you just said, right? Roe, Griswold, and those lines of cases concerned whether it was a general right of privacy. Privacy. That's different from a right to engage in sodomy. So if you start off at a very high level, privacy, you can probably sweep this in. But if you start off at a very specific level, right? Homosexual sodomy, right? It's no wonder this case turns out. So if you're saying, Hannah, is there a deeply rooted tradition and history of privacy in our republic? Would you maybe go along with that? Yeah, the idea that generally cops don't go into your bedroom and arrest you for engaging in sex, right? I think we'd probably all agree with that. So if the court said you have a deeply rooted right to have privacy in the bedroom, that can probably follow from Griswold, couldn't it? I mean, Griswold's married and whatever, is there a deeply rooted right? Maybe. But when you narrow it specifically, homosexual sodomy, well, that's easy. The answer is no. Right? The decision to define the right so precisely, I think, dictates the outcome of the case. Because once you define the right that narrowly, it's easy to get to the result they were getting to. So as a result, the court says, we're not going to announce a new right. Is this a new right, or merely an application of what the right to privacy was identified a decade earlier in Roe and Griswold? Okay. Now the court goes through history. And the history here is actually a little bit complicated. The court says, states have had laws prohibiting sodomy on the books for hundreds of years. The history is actually a little bit more complicated. I just want to mention this briefly. Historically, when a state had a ban on sodomy, it was concerned on predatory behavior. That is as in rape, sodomy, rape, right? The ban wasn't expressly on consensual sodomy. Right? You know what I'm saying, right? It was a criminal prohibition on predatory sodomy, on assault, on rape, as you might call it, right? As opposed to vaginal rape, it's the other type of rape, right? Okay. So it isn't even clear if there was such a deeply rooted tradition of criminalizing homosexual consensual sodomy. And in fact, Justice Kennedy will address this at Lawrence. He says there's a debate about this. We don't need to resolve it now. Okay? Then they go into Lochner, right? And when you know a judge is saying Lochner, you know what's going to happen. He's like, well, we are not Lochner. We're not going to recognize new rights. We remember the New Deal. We're going to stay here, and we're going to stay within our bounds as judges. Then the court says there's a rational basis for this law, right? If it's not a fundamental right, you give it rational basis review, and there's a rational basis. What is the rational basis here? Morality. How do you laugh? Why are you laughing? Morality. Is morality a rational basis on which to criminalize certain acts? Well, let me phrase it a little bit differently. Is moral disapproval, saying we just disapprove of homosexual activity, is that a valid basis? Is that a rational basis to engage to enact a criminal statute? So the answer in Bowers is absolutely yes. And Chief Justice Berger makes this point with a little bit more specificity. But when we get next week to Lawrence and Windsor and Obergefell, the court walks that back. The key holding of Windsor, and you'll see this next week, is that moral disapproval is not a rational basis for the government to act. Merely disapproving of someone from a moral basis, not a rational basis. Wait a minute. Here, Justice White says, if morality is not a rational basis, the courts will be very busy. Think of all the laws we have based on morality. Prohibitions on drugs, prostitution, things that don't really hurt anyone, right? We have a lot of laws where you're engaging in an act that hurts only yourself. Why are those prohibited? But for a sense of morality. Suicide, right? Who cares if you kill yourself? It's your own problem. Organ donations. Who cares if you sell your organs? Whatever. They would say, of course, Josh. Legalize everything, right? Millennials, right? Legalize everything, right? Those kids at the CUNY probably legalize everything, right? But if morality is not a rational basis, on what basis can we have these laws? So Bowers was the high watermark, so to speak, of saying that morality can be a basis to enact these laws. The court would retreat from that with a series of opinions by Justice Kennedy, starting with Romer, then Lawrence, and moving on. Yeah, Arlene?
I just wanted to check, are you recording or?
I'm recording from here. My thing's not working. I couldn't get it in time. But thank you. Oh, it's where's it? I always have backup. This is why when I went to that event at CUNY, I had my own camera. I always record my things in multiple angles, which I'm always very nervous because if my camera breaks, I always have backups. Don't worry. I got you guys.
I rely.
Yeah. Oh, the red light's not on, so you see, one pays attention. Very good. Cameron.
Just for clarification, what did they use as a definition for making a decision on morality? So it's like killing someone.
It is. Well. So look. Look. When you kill someone, someone else dies, right? So there's a victim, right? You can say we don't want murder because there's victims. That's not based solely on morality. But I mentioned use of narcotics, right? You're putting a product in your body that only hurts you. Prostitution? Oh, it does. And they're both consenting. It's a commercial transaction. Suicide, for example, is only one person. There are legion examples of laws we have that you don't think about that are based on morality. Yeah, Abdul?
I don't think it would be fair to say that drugs only affects the person taking it. Of course, it depends on the drug, but you can hurt other people.
The family.
Sure, and more.
And when you're on drugs, you might go into a rampage and go into meth tear.
Depending on the drug, right? But it alters your sense of judgment. So you're more likely to do something that's dangerous to yourself and others.
That's a good point. That's a good point. But the question, Abdul, is can the courts make the decision of whether it is based solely on morality or secondary effects? Right? So what else? The question of the majority or concurring opinion in Bowers. I want to make sure I get to the two cases. Yeah, Hannah?
I'm just kind of troubled by the idea, like using the tiers of scrutiny. If we're using rational basis review here, doesn't that mean that we're saying that people who identify as gay and lesbian aren't a suspect class? Like it's not something we're...
Oh, that was just why is this not an equal protection case? Why? Well, no, one second. Let me answer Hannah's question. Right? Why? Hannah's a good point. Why is this not considered equal protection? The law applies to homosexual activity.
Did they not plead it like as a?
I'm sure they did. Yeah, Evan.
It applies to both gays and heterosexuals.
But couldn't they do the yikwo and say that it has the effect of doing this?
In other words, are husband and wife engaging in oral sex getting arrested? What your point is, right?
No, that's what he says, and I'm saying, but it still has the same effect, just like in yikwo.
Yeah. So the short answer is, the Georgia statute prohibited sodomy among all people, not just men and women. The Texas statute, right, was a little different. The Texas statute just criminalized homosexual sodomy. So there's that. Chase?
So, because he mentions it in Blackman's dissent, how with the sodomy it does apply to everybody, and that's part of the reason I assumed it wasn't an equal protection clause. But then how do they get around and only focus on the homosexuality of the act?
That's right. That's a good point. They narrow it down, right? Because they said the right he's asserting is not a right of sodomy, it's a right of homosexual sodomy. Why can't it just been a right to engage in a sexual act through the statute? It's a very good point. What else? Anything on the majority? I want to do the dissents. Derek, you're next? Okay, Derek. What was Justice Blackman's dissent?
He said that it should have been analyzed under privacy and that there is no justification for the statute. Judeo-Christian shouldn't have been even talked about.
Yeah.
It doesn't provide adequate justification for section 16.
Very good. So Justice Blackman says the right here is not, again, no relation, spelled differently, but Justice Blackman says the right here is not one of homosexual sodomy, it's the right of privacy more broadly, which is recognized in Griswold and recognized in Roe. But then he makes another point, which I think Derek alluded to, that merely looking to tradition is not enough. You can't look only to tradition. You have to look at something broader than tradition. All right? But I just want to pause on this for a second, right? Let's assume the facts are different, right? Let's assume that all 50 states have banned something for 100 years. That's for Chase, okay? Chase, all 50 states have banned something for 100 years. And there's no amendment. This isn't like, say, interracial marriage or school segregation. We had a 14th Amendment, right? All the states have laws criminalizing homosexual sodomy for 100 years. Make up the facts, right? How can a court then come and say, all of you are wrong? You're all wrong. Your judgments are wrong. You're a bunch of homophobes. Read the signs, right? Where does the court get the power to say all 50 states are wrong?
Wouldn't it be, this supremacy clause?
Wait, who's supreme? No. But just bear with me, right? Assume the facts are different. Like, for 100 years, all 50 states banned X. And then suddenly a majority of the court says, no, you can't ban X anymore. How can that be right?
I honestly don't know.
Is the U.S. a party? They aren't. They could do the Lincoln escape.
Oh, you're trying to be cute here. No. Jake, what do you think?
I think it has more to do with how society views the issue as the country's developed.
But I'm saying, but the states, all 50 states still ban it, and there's no development. Jake, let me ask the question differently. Let's say 25 states legalize it, and 25 states still ban it. Are you telling me that people in those 25 states who still have it, you're a bunch of bigots?
Not necessarily.
But to say that you're depriving someone of liberty interest means that you're being bigoted, right? That you're that you're being homophobic, or whatever word you want to use, right? To say that you're doing this based on morality is saying your sense of morality is basically homophobia. So there's a cost, though, right? To saying that a long-standing tradition has no rational basis means that you're basically being hateful. You're yikwo, right? You're doing this as a hateful reason, not any sort of non-benign reason. This will make more sense when we do the gay marriage case. What I'm saying now will click a little bit more. Okay. So, other questions on the dissents? I want to move on and do the other cases for today.
Sure. What was the answer to how can the court's overruled.
Oh, I have no answer for you.
Okay.
This is an open-ended question, my friend. Yeah, Jake?
I just have a question about, I guess, Justice Powell's concurrence.
Yeah, let's look at Powell's concurrence. Okay, that's good. Yeah, thank you.
And why is it so short?
Oh. Would you rather be longer?
Well, I guess I'd say.
I think I added that because I wanted to put the footnote in there.
Okay.
Yeah, so everyone knows the footnote on Justice Powell, right? This is a very famous story, which I read about at the time, and I was like, okay, I gotta put this in the book. Justice Powell voted in the majority for Bowers. And at the time, he apparently told his colleagues that, I've never actually met a gay person. And it turns out that one of his law clerks at the time was gay, and there probably were others who maybe weren't so public about it. There's an argument that as the court became more aware of what it meant to be a gay person, that they changed their opinion on this topic. This is your point a moment ago about public interest being awareness. But Justice Powell later in life said this was a mistake. He regretted this vote. It would only stand for about, about 17 years. It didn't stand that long because Lawrence overturned it in due course. Yeah? Do you have that hand?
How can you compare this case to Gickwell when that was equal protection and this is due process?
Well, why wasn't this case equal protection? There's a question raised. Why wasn't this pleaded as an equal protection case?
It didn't deprive of classification.
Well, it targeted an act that homosexuals engage in more often than heterosexuals. No. You can plead that. Yeah.
It makes an argument. It makes an argument that why couldn't Gickwell be a process case?
I think Gickwell was a due process case. That's my outlier position. It wasn't equal protection. I think it was about liberty, interest, and property rights, running a business. Anything else on yeah, Laura?
Maybe I guess to comment on Sam's question, and also what you said that homosexuals probably engage more in this type of activity.
Yeah.
If they did choose like the equal protection route, I think that would also base it off of like the stereotype that they're trying to like stay away from.
Oh, that's a good point. The intermediate scrutiny stereotyping. Yeah, that's a good point. Yeah.
So it's probably like just another reason.
If you notice, the very last sentence in Bowers, this little footnote says, we're not considering, was it the 9th Amendment and the 4th Amendment, the 8th Amendment, and they threw the kitchen sink, and we're just not considering that stuff. They weren't going to answer it. Yes, Regina.
I think what was interesting that
Oh, yeah.
and just in reading some of the opinions, it's been frustrating since it's fussy. But I feel like when the court has the opportunity to actually, do something, I feel like sometimes they kind of retreat and hide their hands sometimes. And it's frustrating because it's like you have the opportunity to, put things into an action or, get rid of things even though they are, in standing tradition, but you choose not to.
How should a court know when they should and shouldn't do that?
I mean, I guess there's no way to tell, but I feel like on other stuff like abortion, they went guns blazing in and said, hey, no, this is wrong. But then on other things, they retreat.
So it's a good point, right? In some cases, they go guns blazing, like your phrase, Regina. In other cases, they abortion, okay, it's not, right? Yeah, good point, good point. I like the way you phrase that. All right, anything else on Bowers? Yes, ma'am. Yeah. I don't have any definitive answer. That probably played a role in this. The concern of gays and AIDS probably, think back to Roe with talking about overpopulation and race and everything else. Probably. I don't know. Google it. Maybe there's something on this. I don't know. But good question. What else? All right, let's do Casey. What drives students nuts about the abortion topic is you have different tests depending what year you're in. I mean that quite literally. We did this at the start of, or at least an hour into class, the framework from Roe, right? That during the first trimester, basically the state can do nothing. During the second trimester, the state can enact regulations for the health of the mother, but not for preserving fetal life. And then the third trimester, post-viability, they can regulate or even ban abortions on the basis of fetal life. So if I were to ask you what's the holding of Roe, you would have told me this, right? A little press release, maybe a little bulleted thing at the end. This is what you would have given me. Then we get to Casey. And it's not this anymore. So you're saying, wait a minute, Josh, did Casey overturn Roe? Well, they said they didn't. Casey said we did not overturn the essential holding of Roe. They use that phrase over and over and over again, right? We don't overturn the essential holding of Roe. Now, what does that mean? What is the essential holding of Roe? If you had asked me, if I was a law professor back in the 90s, I would have said this, right? I think we agree. But they drew a different line, right? Jonathan, you next? Jonathan, what's the line that the Casey court drew as the essential holding of Roe that's maintained? What's this essential holding of Roe?
That women have a right to control their bodies as far as abortion goes, as long as the state doesn't place an undue burden on them.
Okay. At what point does that test no longer apply?
Which one?
The undue burden test. There's an important point where the undue burden test no longer has relevance.
Isn't it viability?
Bingo. Right. So we have here, right? This is your test for Roe. Okay, this is your test for Casey. Before viability, you apply what's called the undue burden test. After viability, basically whatever they want, right? Okay, after viability, can ban abortion if they want. Okay? The key thing here is that the concern for fetal life is existing at all 9 months. Okay? In Roe, fetal life only plays a role at the final trimester, that is months 6 through 9. With Casey, a concern for fetal life plays a role at the entire stretch of the gestation. Okay? Why does this matter? Because under Roe, basically nothing was permitted during the first 3 months. Now, you can impose a restriction during the first 3 months, so long as it does not impose an undue burden. An undue burden. Clint, help me out here, my friend. What does this phrase, undue burden, mean?
If I had that answer, I would go to the Supreme Court. No one knows what that undue
Well,
burden is.
give the court a little bit more credit, right? Just walk me through what they say it means.
Their definition is exactly what they said. In our view, the undue is an appropriate means. Okay, a finding of an undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus.
Okay, very good. So let me read it to you again, right? A law imposes an undue burden if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. This is in the press release end of the opinion, right? It's summarized at the very end. So we have undue burden. We have substantial obstacle. Evan, what's a substantial obstacle? I'm not trying to mean. This is the test. I'm giving you what the court said. What's a substantial obstacle?
Well, looking at the next case, it would be...
Oh, no, I'm not there yet. No. They changed it again for Holman's Health. We'll get there in a few minutes. Okay. I want to do Casey first, right? What's a substantial obstacle?
Just making it any more difficult for the mother to...
Any more difficult or really more difficult?
Much more difficult.
Much more difficult. Okay, I think that's probably the best we can get out of you, right? It's got to make it really difficult, right? Not just a little bit more difficult, substantially more difficult, an obstacle, right? This phrase undue burden, the court took, actually not the court, but the plurality took from an opinion from the 80s. But it's a phrase that gives students a little difficulty because it's hard to extend. Now, is that George?
Jeffrey.
Last name George, right? Jeffrey. That's close. Jeffrey, is there a difference between the undue burden test and strict scrutiny? Is there a difference between the undue burden test and strict scrutiny?
Well, you could prove that something does have an undue burden. It's actually
In other words, could a law survive the undue burden test but not survive strict scrutiny?
yes.
Okay, I think that's right. So imagine, right? We have, you ready for this, right? You have the rational basis test. You have intermediate scrutiny, right? You have undue burden. And then you have strict scrutiny. Yeah.
But for the undue burden test, is the burden of proof on the plaintiff?
No. Who has a burden of, well,
I mean, they need to show, like, this is an undue burden.
well, in Casey, who has a burden of proof? The answer they might be different for the Texas case. Texas has the burden of proof, without a doubt, in the second case. But who has the burden here, Casey or their Planned Parenthood? I think you're right. I think McKinney, he stole my point for 5 minutes now, but I'll do it now. I think in Planned Parenthood, the burden is on, in the Casey case, Planned Parenthood has the burden of proof. But in Texas, Women's Health, I think it's not the clinic, it's the state has the burden.
Okay, so it can go.
Well, this is why I think Women's Health expanded the standard review, made it more rigorous.
Thank you.
Thank you for a good question. So everyone get the basic test, right? Now, Casey was not a majority opinion, right? It's what's called a plurality. A plurality. That means it has only 3-member majority. The history of this case is, well, legendary among Supreme Court people who care about this stuff. But it's a very famous story. So what happened? Throughout the 1980s, there were several cases where the court came very close to overturning Roe v. Wade, but they were 1 vote short. Fast forward to 1991. Justice Brennan retires, replaced by Justice Souter, Republican appointee. Justice Thurgood Marshall retires, replaced by Justice Clarence Thomas, a Bush appointee. So now you basically had 8 Republican nominees to the Supreme Court and only 1 Democrat nominee. And the only Democrat was Byron White, who dissented in Roe. So this was looking like, this is our shot, right? This is the case to overturn Roe v. Wade. And after the initial conference, there was a 5-vote block to overturn Roe. Then, as happens, Justice Kennedy changed his mind. And there's a famous story. Kennedy and Scalia were actually neighbors. They lived very close to each other. And Scalia went for a jog with Kennedy. He's like, don't worry, I've got this, so we're going to do it. And the next day, Scalia circulates an opinion. And then Kennedy's like, nah, I'm not going to join that one. We're going to do my own opinion, right? So he had a separate opinion from Kennedy, O'Connor, and Souter. What's called a plurality. And they advanced this new undue burden test to decide when restrictions on abortion can survive, right? And they were very careful, right, saying, we are not overturning Roe. Alan, why do you think they did these pretzels, these gymnastic somersaults, twisting and turning, before, they basically did all these like gymnastics, right, to say, we're not overturning Roe, we're just going to change a lot, right? Why'd they do this?
That's a good question. But
it's a very good question. That's why I asked it.
Traditionally, the court doesn't really overturn its own cases.
All right. So Alan, I think, is segueing to my next topic. So Abdul, this question is for you. First sentence. Liberty finds no refuge in a jurisprudence of doubt. Liberty finds no refuge in a jurisprudence of doubt. What the heck is going on there? What does that mean?
It sounds like they're trying to say that we have to take a stand and we can't be wishy-washy about this. So like Roe, and this is a quote from students, has become a part of the national framework on dialogue on this issue of abortion. So if the Supreme Court says, on one case, this is the framework, on another case, they take the complete opposite point of view, and they keep doing this, it's like the individual is going to be...
So it's better to stick with a wrong decision than to acknowledge your mistake and move on.
They've never said or implied that, it was wrong.
Oh, they do.
You're saying...
Yeah. No, they say parts of Roe aren't essential.
Parts of it, but they don't say that we were wrong as a court. They never say that.
come close. They come close, especially in the part of fetal viability. They say Roe said that wasn't relevant in the first trimester at all, and they said that was wrong. But Abdul's point, I think the other point is absolutely correct, right? Roe and Casey, right? The court spent a lot of pages writing about why stare decisis should not have. I'm sorry, why stare decisis should be stuck with here. And what they're effectively saying is, if we overturn Roe, we will signal to the population that the court is merely changing its mind based on new composition, and that message will be harmful to the court's own legitimacy. Everyone understand what I'm saying, right? That if you take this position that the court can overturn a decision merely because you have a different composition of the court, then people will view the court as a political institution.
That's a precedent in and of itself. So that's a precedent. The case where you're saying it's precedent.
Right. Yeah. Good point, Abdul. Now, McKinney, what does Justice Scalia say in response to this? By the way, Scalia's livid here, right? He is. I mean, he's always angry, but he's like really, really pissed off here. McKinney, what's Scalia's response on the stare decisis point?
He goes into a lot of detail about how the Constitution doesn't actually say anything about abortions or how it's been traditionally, that it's been traditionally prohibited, but he kind of says that it's not a constitutional liberty, and it's not really violating stare decisis in that manner, because this was a statement that they just kind of made up anyway.
Okay, very good, very good. But McKinney, I want you to talk about his discussion of stare decisis, right? We know Scalia thinks this right to abortion is made up, right? That's easy. I can tell you that in 2 seconds, right? There's not much of a debate there. But McKinney, the question I had for you was, what does Scalia say about stare decisis, right? Why does he think it's a mistake to stand by this precedent?
I'm drawing a blank here. I'm sorry.
Okay, Yvonne? Anyone? Yeah, JC.
Because reason finds no refuge in this jurisprudence of confusion.
Ha! Oh, what a good line. Say it again.
Reason finds no refuge in this jurisprudence of confusion.
So what does that mean?
It means that if you're going to set a jurisprudence down, but you change your mind on what you supposedly stood firm on, then nobody knows what you're talking about.
Yeah. So if you're just a random person reading a newspaper, right, and you pull up the headline of the New York Times the day after Casey, it says, Roe v. Wade upheld. If you're a lawyer, or you're in an abortion clinic, and you read this page, it's like, uh-oh, stuff's changed, right? We have this new framework. We have all these new laws that are going to be enacted. And Scalia says it's not real to say that this is keeping Roe in its place. But Scalia's bigger point is, if there was a mistake, right, we say the court made a mistake and made this right up and didn't protect it correctly, the way to remedy that is to get rid of it altogether, not to just do it less bad, right? That if you did something bad before, the way to fix it is to undo it, rip the band off, not to do it half-assed.
Very much confused. What he was talking, Scalia was talking about the states acting policies that are too good, and Scalia talks about a state to pursue that interest only so long as it is not too successful. Reason finds no refuge in the jurisprudence of conclusion. You're saying that he was supporting stare decisis with that?
I think it speaks to it, yeah. Yeah. And then
my question goes back to comparison between these two tests, strict scrutiny and the.
Well, it was never strict scrutiny. Notice, Roe never said strict scrutiny. They never used that phrase.
Yeah, but again, when we were comparing in strict scrutiny, we have this governmental interest, but on the burden, the focus is more on whether there's an obstacle on the path, and nothing is mentioned about the governmental interest. Is it implied there, or?
Well, I'll tell you what. Ask me that question when we do Breyer's opinion in Holdman's Health, because it does come in. Is the state actually pursuing any benefit to women, or is it merely a burden, right? Actually, let me answer Damon's question now. It's a good question. Casey focuses almost exclusively on the burden to women. It doesn't discuss the benefit of these abortion laws. The Texas case, right, Holman's Health, discusses is there a burden and is there a benefit. It does both sides. So, give you a preview, Holman's Health brings abortion very close to strict scrutiny. I'm not sure there's any difference at this point, because it does both the benefits and the burden, what's state's interest and how it's being restricted. This is more intermediate. It's only what's the burden. Is it a burden of a certain size? But good point, Damon. Yeah, Alan.
What do you think about that logic? Because it seems to me like Scalia was just really conceding, kind of like accepting defeat and not trying to hold the structure as opposed to creating more friction between the two.
You think he was conceding this point? I think he was blistering. He was in dissent. What could he have done differently?
I just think that's a horrible logic. It's kind of like we messed up, but let's try to make it less bad, as you said.
Oh, so you think the majority said we screwed up? Let's make it less bad, right?
Yeah.
Okay.
And then on that basis, then it goes back to everything we kind of discussed here in this class. Okay, slavery, interracial marriage. Okay, at one point, all of that was law, but it was overturned.
So yeah, Scalia, in his Casey opinion, is this in your book? We talked about Dred Scott.
Yeah.
Right. So I never remember if it's in the book or not. Scalia at the very end compares Roe to Dred Scott. He says, "Look, Roger Taney was trying to solve a major divisive social issue with an opinion, and it didn't work. Rather than patching up Dred Scott, we should get rid of it." And he basically makes this analogy. Now, you often see Scalia is comparing abortion to slavery, and this is what they're talking about, right? He wasn't comparing abortion to slavery; he's comparing Roe to Dred Scott. People say abortion is like slavery. But I think Alan's point raises a good question, right? If the court makes a mistake, should they just fess up and admit it or not? But what's the cost to admitting the other one was a mistake? This is like your midterm question, right? If Jefferson had submitted the proposed amendment to Congress about the Louisiana Purchase, would people then doubted whether the purchase was legal? Is it better as a side to just move on and say, you know what, we're going to pretend this didn't happen, don't ask any questions, right? Is ignorance bliss? Do you just move on? Alan?
A good point, but again, it goes back to kind of like your moral compass, and the reality is that it's a nation of laws, and you have to abide by the laws.
That's Scalia's opinion, very firmly, yeah. Scalia often says we need the rule of, Scalia would say the rule of law is the law of rules. The rule of law is the law of rules, that you have a consistent application of the rule of law. If you want, I have an extended discussion with the protesters on the rule of law for 15 minutes. You can watch it later in the video, but we talk about this back and forth. I was actually quoting from the John Adams Massachusetts Constitution of 1780. They weren't interested in that. They weren't interested in that answer. But anyway, I'll give you the same. All right, I got to move on. We're not going to finish. Any other questions on Casey? Right. So we have to know, is Casey now the line is before viability? You give the undue burden standard. Right, which talks about substantial obstacles. Cameron?
If you were to try a case in front of the Supreme Court, could you use this case as a different definition of stare decisis? Like Scalia points out that stare decisis is intolerable.
You know, after Bergefell, where the court overturned thousands of years of marriage laws, stare decisis doesn't have much weight anymore. At that point, this was the question I was getting at with Jake a minute ago, right? If states been doing something for a very long time, of course, now you can't do it anymore. Stare decisis, that's very... It's hard, yeah, John.
I don't know how that aligns with universality.
You reading my stuff? What do you mean just universality? You are. After class. It's a good question, but I don't have time for today. I'll answer after class. He reads my blog way too closely. This is not good for your health. Jonathan, then the last question, move on.
How do they balance this undue burden with other kind of rights that are applied in this specific law, like the minor getting consent from her parent? Well, the minor doesn't really own herself wholly until a certain age legally.
Nope. Yeah, there were a bunch of cases in the 80s about what's called judicial bypass, right? Where if a female teenager wants an abortion, the parents say no, that the teenager can go to a judge and seek a bypass. Well, a lot of cases in this in the 80s, and we don't have time to
But that's
cover.
a process. But just outright giving her the right without even telling her parents.
Kids don't have complete rights on their own. There was called in loco parentis, where the government operates in the place of the parent. So there's some place where the state can step in if it's in the best interest of the child. Think of like a custody, right? If you have an abusive parent, the state can intervene and replace the child in a foster home, for example. So you do have some law on that. And loco parentis, I haven't said that in ConLaw in a very long time. Okay. I got to move on. Let's do Holman's Health. This is a recent case. What was it 2016? So not even 2 years ago. Probably you remember this. Read about this in the news. Who's next? April, I think you're next. Want to give me the facts? Who's in Holman's Health?
So Texas passed 2 laws governing abortion.
Okay.
And one was a provision that adopted that women had access to. I'm sorry, the first required that a doctor performing an abortion had admitted privileges at a hospital no more than 30 miles away.
What was it, April? What does it mean admitting privileges? What does that mean? Very good, right? So I understand what this means. It means if you are a doctor who performs an abortion, you need privileges to be admitted to a given hospital. And the thinking was, well, if there's something goes wrong, that doctor can treat you to the hospital rather than some unknown doctor. Okay, that was the first provision. April, what was the second law at issue? That's right. What was the second type of laws? The first one was admitting privileges. What was the second one?
They required the abortion facility to meet
Very good. Yeah, what are these surgical standards, April? Nick?
It says that the minimum standards for an abortion facility must be equivalent to the minimum standards under the code.
Right. So in other words, if you want to perform abortions at any stage of the pregnancy, you need to be equipped to perform surgery. 1 second, Carlos, promise. To have the same standards as surgery center, even if you don't have staff to perform surgery, right? Okay, Carlos, your question?
Oh no, I was just gonna comment on this because I do remember actually watching a documentary in this case last year or when it was going on. One of the biggest issues with that code was that it specified like it went super deep, even to include like the width of certain hallways.
Right, because you got to put a stretcher through.
Yeah, so the width is so uncommon that it's just only found in certain hospitals, like dedicated to certain types of surgeries, and it basically banned away a bunch of medical facilities in the whole state because of that requirement.
Very good. So, Carlos, let me give you this question. Why is this case called Holman's Health versus Hellerstedt and not Planned Parenthood versus Hellerstedt? If you were driving 45 past UH, you see the huge Planned Parenthood facility. Why wasn't that the one bringing the lawsuit? Take a guess. It's a big facility. You've seen it, right?
Yeah, I've seen it.
Do you think that one complied with these standards? Yeah.
May, but I don't know if they do.
Yeah. No, they did. They did.
They do the abortion.
Yeah. So, Stephanie?
I was just going to say, Holman's Health wouldn't have been able to meet the standards.
Yeah. Look, there's a picture. It's a pretty small place. This one that was in the Valley or was in El Paso? I can't remember which one this one was.
That one's in the Valley.
Yeah, I think. Yeah. So this case was brought by Holman's Health, which is a smaller clinic, and they do not comply with these surgical standards. The facility is in Austin, in Houston, in Dallas, and San Antonio, and missing other cities. You got
El Paso.
El Paso, yeah. The clinics in the big cities all complied with this standard.
El Paso didn't.
No, I'm sorry. No, okay, thank you. El Paso didn't, but San Antonio, Houston, Dallas, and Austin, I think they all complied, right? Okay, good. But the smaller ones in the Valley and out west did not comply. So the argument here wasn't this would shut down all clinics in Texas, but it would result in certain clinics not being able to comply. And I think Carlos alluded to this. You can't widen hallways in a building. You have to basically restructure the entire facility. Okay? This was challenged in court almost immediately, had a fairly complicated posture. The Fifth Circuit upheld the restrictions. Danielle, what did the Supreme Court do here? Stacey, what did the Supreme Court do here? Okay, good. Why did Justice Breyer think that these laws imposed an undue burden? Okay.
If they were located in a city
drive very far. So, Regina, let me ask you this question. In the Casey case, in the case we were in a minute ago, the court upheld a 24-hour waiting period, right, to obtain an abortion. And if you think about what a 24-hour waiting period means, you go somewhere, might not be where you live, wait to 24 hours, maybe get a hotel or something, right? That requires a lot of traveling. Why is this case different?
Well, because they were saying like the 24-hour waiting period didn't really impose an unnecessary burden on them, whereas widening hallways, accommodating parking lots, things like that would be expensive, and closing these clinics would force these people to go out of their way to get to.
Well, that's my question, right? If these clinics close, why can't people drive 8 or 12 hours? And why is it any more of a burden than a 24-hour waiting period? Yeah, so one of the issues in this case is Texas is really big, right? And if you don't look at a map, and I did the math on this, right? There are places in Texas we have to drive 2 hours to go to a Walmart. I did the math, right? There's some really remote places. And a lot of these clinics were in these fairly remote places. One of the issues was, well, what if there's a clinic in New Mexico on the other side? Does that count? And there's a clinic in Louisiana on the other side. Does that count? This all came from litigation. But what Justice Breyer said here is that the burden of making people travel, even if it's only a small percentage of the women in Texas with reproductive age, is still an undue burden. Yeah, Warren?
There's still more of that when it comes to the undue burden that was involved in that case. In the Texas law, I think it was a 3-day waiting period between being advised and being able to start the procedure. The procedure that was most common at that time was sort of a chemical abortion, which you would take a pill for. It was a 2-step process. You would take one pill and then come back a day later for the second pill. So there were several trips that you would have to take to the doctor.
Good.
And you would have to get a hotel. You have to drive clear across the state, get a hotel, and stay there. And then you have to child care for your kids and all kinds of stuff. That it was a huge, huge burden. It cost thousands of dollars per trip.
Very good. So the first aspect, right, with the surgical standards would require closing a lot of facilities. Now, couldn't these facilities come up to spec? Perhaps would be very expensive. So that's the first part of the holding. The second part concerns the admitting privileges, right? JC, why did the court say that the admitting privilege requirement imposes undue burden on the female, on women in Texas?
It turned into a math issue.
A math issue? What's the math issue?
Basically, there were supposedly between, it was like 120 to 144,000 people seeking abortions. They were going to have 8 clinics, and it worked out to something like they were going to have to see like 1,200 patients a month.
So they couldn't keep up with the demand, you're saying?
Basically impossible.
Now, JC, let me finish this question for you. The admitting privileges would definitely add a burden for women, right? Why did Texas say the admitting privileges were necessary?
They talked about the Dr. Frankenstein in Pennsylvania.
Yeah, Kermit Gosnell, yeah.
And then the majority came up with the analogy, or kind of relevant today, determined wrongdoers already ignoring existing statutes and safety measures are unlikely to be convinced to adopt safe practices by a new overlay of regulations.
Yeah. So Justice Breyer has this one line where he says, determined wrongdoers already ignoring existing statutes and safety measures are unlikely to be convinced to adopt safe practices by new overlay regulations. He doesn't really mean that. He would never write that in a Second Amendment case, right? He doesn't actually mean that. But what this opinion does is it elevates abortion district scrutiny, right? It means even if you have a pretty good reason why you're doing this, it's not going to be enough. And he does this in a very subtle way. Casey only considers the burden to women, right? Does this regulation impose an undue burden on women? It's all about the burden for the women. In contrast, this considers not only the burden, but also the benefit. He asks, does the admitting privileges regime impose any benefit for women? He says, no, there's no actual benefit. Most abortions have few complications. Most abortions don't require you to be admitted to a hospital because you can go to an ER. You don't need this doctor to have this privilege. What about the width of the hallway thing, right? Thing Carlos mentioned a minute ago, right? Yeah, maybe in the extreme case, if you need surgery, you can't put the gurney down the hallway. But a lot of these are chemical, that Warren mentioned. They don't require any attention. So whatever this is, right? Whatever this is, it's not undue burden alone. It's a strict scrutiny standard. JC?
Was there any state funding involved in any of this?
Stephanie, do you know?
No, Texas, there's no state funding allocated for abortion providers or any affiliates. So, public schools, like University of Texas, can't give student research to research abortion because of the affiliate ban. But Medicaid and Medicare, Medicaid funds abortion.
I think that, did I answer your question, Jonathan?
The legislation had said everybody already in existence is grandfathered, but going forward, these are the new regulations. Would it have been upheld?
Yeah, that came up in arguments, right? Wouldn't one way to save the statute is say, well, we won't apply it retroactively, we'll apply it prospectively. Or maybe you can sever it, saying in the areas where, like in the Valley or El Paso, maybe we won't apply the standards there, we'll apply them in San Antonio and Houston where they can't afford to have it. But Justice Breyer said, nope, we're going to strike an entire thing. The entire thing, right? This is Justice Breyer who wakes up in the morning and dreams about deference, right? He strikes out the entire, he does. I mean, he's like, how can I defer to the government today? You know, make deference great again, right? That's Breyer's mantra. But here he asks, and I mentioned this point when we talked Lochner. Whenever I read the Breyer opinion, and he says the hallways, right? I think of the ventilation laws in Lochner, right? Saying that this is not a safe facility, and this basically comes full circle. This is giving abortion rights strict scrutiny. And critically here, you have a 5-justice majority. Casey was only a 3-justice plurality. But here the 5-justice majority adopts Casey in its entirety and some, and adds this additional oomph about what are the benefits of this ritual and procedure, not only what are the burdens.
So will strict scrutiny and undue burden always be present in an abortion case? Will that always be?
You know, I think, if you ask me my opinion, not just as an exam taker, but as a litigator, you call it undue burden, but the court's going to treat it like strict scrutiny. I think that's the answer to your question. It's the sort of rigorous review, right? And now let's go into the Thomas dissent, right? Justice Thomas is livid here. Scalia had passed away a few months ago, so this would have been a Scalia dissent. So I think Thomas had to pick up the. He may have even used Nino's draft for all we know. I mean, we don't know. Where's something weird? On the Ninth Circuit Court of Appeals, after a judge dies, you can still issue an opinion. It's a bizarre practice. So Judge Stephen Reinhardt, this very prominent judge in the Ninth Circuit, died a week or two ago. And he had an opinion come out the other day. And it says, this case was decided before his death, we're still going to release it. That's weird. I don't like that. You're dead. Go away. You have lifetime tenure. You can have beyond the grave tenure. We don't have that. No. But anyway, Scalia was dead at this point. So I'm guessing Thomas picked his mantra. So what really pissed off Thomas was 2 cases decided in the same month. Fisher and Holman's Health. Both involve Texas. Ready for this? In Fisher, he says, the court purported to apply strict scrutiny to a racial classification, upheld it. But here, they purport to apply undue burden, but they struck down the Texas law. Right? Why this disparate treatment? And Thomas is he's livid about this. Any questions on the Thomas dissent in your minds? Let's see. What I'll talk about. Thomas also makes another point that's worth discussing. Why are certain rights treated differently than other rights? And why does the court have this sort of variable regime of fundamental, non-fundamental, undue burden, this or that? He says we can't decide to pick and choose rights. Thomas, I think, would just get rid of all protection for rights that are not written down. He rejects substantive due process in its entirety. He also attacks the tiers of scrutiny as a meaningless formalism, because the court employs whatever standard it wants in a given case. They're just empty words. Yeah.
So you talked about they could have done some judicial reformation, redoings. That doesn't happen often, though, right?
Judicial what?
Where they changed the law, so if they would have applied it only to the places in San Antonio.
You mean like a saving construction?
Yeah, except from your favorite case. Has that ever occurred?
Yeah.
I mean, you know,
Yeah.
we haven't studied many cases. where
So
this
there's
is
doctrine called severability where they sometimes do stuff like that. Stephanie?
Oh, I wanted to. So whenever HB2 was passed and it shuttered all the 8 of the clinics in Texas, they permitted the clinic in McAllen to remain open because even though it wasn't going to meet the standards, because if that clinic had closed, there wasn't going to be a clinic around there for 400, 500 miles.
And they left the ones open in El Paso because of New Mexico. There was options across the board. Was that the thinking?
El Paso didn't remain open right after they passed it, but the one in McAllen did.
Thank you. It had a very complicated history. It went for like a couple of years, too. It went up and down a few times.
So to answer my question, it doesn't happen very often, does it? We haven't studied any cases where that occurred aside from the Obamacare case.
There are some cases I gave some thought, but the court does apply ways to construe a statute to leave parts in place and not other parts. I think they probably could have said, as applied to clinics already in existence, closing them would impose an undue burden. But for new clinics that will be constructed, they can consider these new standards to build. I don't think that would have been that crazy of a ruling. I mean, it would be within the bounds of, precedent. Right? But in other words, maintain the status quo, but if you're building a new one, measure your hallways wider. The admitting privileges, you wouldn't, that I don't think they could have saved, because that would apply no matter when. But the surgical standards, they probably could have, I don't know, Stephanie, is that? Would have been feasible to say, leave the current facilities in place, but if you're building a new one, consider these standards.
I think that would have been
Feasible. Maybe not ideal, but possible, yeah? Unnecessary. Feasible. Yeah, I can live with feasible. All right.
But that doesn't happen very often, right? Or does it? That's what I'm searching for. Because if I put it on exam, that, hey, yeah, they can save it by doing this.
Are you guys packing up? We're not done yet. There's still a few minutes left. It's gone. Good. And who's your question, please?
So that doesn't happen very often. Is what I'm asking. Aside from the Obamacare.
I'd have to give it some thought. So let me summarize a bit for you, right? So far we've done all these cases involving substantive due process, and you have this fundamental rights test, and you have this deeply rooted test. And then you get to Casey, and they don't really speak about fundamental rights. They don't really speak about deeply rooted. They speak about liberty. This is Justice Kennedy's favorite word in English language after dignity, right? His favorite word is liberty. And what you'll see with Justice Kennedy is he begins to develop this framework that if he thinks something impacts a person's dignity, it warrants more protection by the courts. But he doesn't use the phrase strict scrutiny. He doesn't like it. So what's going to annoy the heck out of you in the next couple classes is we're not talking about scrutiny anymore. We're not talking about fundamental rights anymore. We're not talking about deeply rooted. We're talking about dignity of the person, whatever that means. Anything else? Well, thank you very much. I'll see you guys next week. Or some of you on Saturday. We are bright and early. No. I'm Sunday. I know on Saturday. I think just Sunday, right? Whatever. I'll see you later.